Hi everyone, this is Declan Kissane. He's a barrister in Queensland, and I'm Matt Hudson from SV Partners. So today we're going to go through and talk about, the practical considerations when dealing with insolvent construction companies, the rights of, the subcontractors, developers, builders, and I guess the external administrator. But before we start, I'm just going to give it a couple of minutes. Or a minute or so for people to join, and then we can get going. But what I would say is, anyone online, feel free at any time to leave a comment. Interact with us as much as possible. Send as many questions as you like, and I'll ask the expert, and then we can go through and have those discussions. If you see me looking to the right or down, I'm just trying to sort out multiple different streams that are going on. So please bear with me. I've got quite a few people on already, so we'll get started in a second. So thank you everyone for joining today. Looks like we've got a pretty decent turnout, so thank you. I'm joined today by Declan Kissane, who's a barrister here in Queensland. Thank you, Declan, for coming on board.
My pleasure.
Being one of my early guinea pigs, being part of this process. We've got quite an amazing lineup coming over the next probably 6 months. We're going to be talking about all the different hot topics as they relate to insolvency. I thought I would get Declan in today to talk about construction insolvency. We're certainly noticing a big uptick in I guess those builders, developers, subbies who are really struggling, because of all the price increases going on around the country. We've certainly noticed, the price of steel, copper, piping, and stuff like that, just astronomical price increases. So, and then also not to mention the supply chain issues that go with that. So, what we wanted to do today was really focus in on that, have a look at what the rights are for subbies who might be dealing with an insolvent builder or developer. And I guess also look at the rights of the developer, look at the rights of liquidators, look at the rights of the developer. So that's why I've got the expert here today, Declan. I've known Declan for pretty well my entire career now, about 10 years. And pretty much throughout, that whole time you've been a barrister, Queensland. I knew that you had grown up in Mackay, so you're a North Queensland boy, and born. I don't know if you're Irish heritage at least. I don't know if you're born in Mackay, but I've always known you as that sort of construction, building, insolvency expert. So maybe you just share a little bit about yourself.
Sure, Matt. Pleasure to be here. This is actually my first time on LinkedIn Live, so that's a nice experience for me. I was born in Ireland, and I did high school in North Queensland in Mackay, and then moved to the Big Smoke when I commenced practice as a solicitor. I was in practice as a solicitor for about 7 years, and then I went to the private bar in early 2010, which was just after the GFC, and there's a lot of parallels I see in the environment at the moment with what we encountered back then. So I think it's really timely that you invited me on so we can have a chat about what's happened historically, and tools that may not have been used then, or some misunderstandings about the use of some of the tools that are available, and help people in wherever they're coming from, and whatever aspect of the construction industry they're in, to gain some insights to hopefully have a better outcome, and be aware of what's available for them.
Yeah, and you definitely would have seen the ups and downs of the insolvency market over those 11 years. Putting out your crystal ball for the new year, and I'm definitely putting you on the spot here. What are you
Good
thinking?
way to start.
Yeah. What are you thinking? Next year, are we expecting that, I guess, insolvency avalanche, or are you a bit more pessimistic on that front, or optimistic if you're not an insolvency practitioner?
Look, I'm probably an optimist at heart. I think that, particularly in Queensland, the experience was that there was a lot of regulation put in place to assist the industry, and ensure that licensing was, and also financial stability was a bit more robust among contractors generally. And you would hope that in the current environment that those robust structures that should have been put in place and need to be maintained will assist people going forward. But there's a bit of a paradox at the moment in that there's a whole lot of work on, but for the reason that you've mentioned, there are a lot of contractors that are obviously very, very concerned, and therefore people up and down the contractual chain are concerned because the head contractors have problems and the subcontractors all the way down the chain are concerned about price increases, then it affects the industry overall and its maintainability. So, it is a paradox that there's the work there but yet there is concern about financial stability.
So just anyone listening, feel free, please, to comment or ask any questions. But we're going to get on with our example matter today. So this example is, I guess, a bit of an amalgamation of some of the things I'm seeing, the inquiries that I'm seeing in the market at the moment from, I guess, builders or subbies or even developers who are really doing it tough and are very much in that paradox of way too much work but not enough supply in terms of being able to get, whatever they need to finish the buildings, or there's been such a large increase in prices. So what I want to do today is I want to go through the rights of, I guess, developers, builders, subbies when it comes to, I guess, that insolvent company somewhere in the middle of that. And today's example that I want to go through is Bob's Builders Proprietary Limited. That is probably a bit of I think that example has been used a little bit by me in the past and some others. But Bob's Builders is a resi builder. So it basically specialises in 2 to 3 lot little townhouse developments around the city. It's got about 4 or 5 of those on the go at the moment. And what it basically had done is, late 2019, early 2020, it's, really excited. It's really thinking that it's got its next big year coming up, signing all these contracts, trying to get all these developments on the go, and then COVID hits. So the developer on those projects have basically said, look, we can't really do a lot for this year. There's so much uncertainty. And so they put them on hold for 9 months. And now, with property prices increasing so much, the developers are saying to the builder, to Bob's Builders, look, let's get in and get these projects done. And Bob's Builders is turning around and saying, well, firstly, I'm struggling to get supply. And secondly, prices have just gone astronomical. So I can't really complete at that mark. So unfortunately, Bob's Builders, its debts are too high. It doesn't meet the small business restructuring process. And there's some debate about whether or not in Queensland you're even allowed to do that with a QBCC, but let's leave that for another day. And if you have any questions about small business restructuring, please visit the SV Partners website or my LinkedIn. There's heaps of information about that. But basically what's happened with Bob's Builders is it's gone into external administration. Liquidators are appointed, and really what we're trying to do or look at here is, obviously there's some uncompleted projects. Some of these projects are 80% complete, 90% complete. Others are 20% complete. So is there any recoverability on those assets? So maybe if we can start, Declan, with the subbies. So what's their rights? And so let's say you've got the plasterer or the electrician who's done all this work for the builder, in particular on those 80, 90% projects, haven't been paid yet. What do you foresee as their rights and key things for them to consider?
Yeah, sure. Probably there are a number of tools available to them. The best tool, without a doubt, for a subcontractor would be the situation in Queensland where under the BIF Act, which is Building Industry Fairness Act, which creates a structure for subcontractors' charges. And that is a really useful tool because it secures money further up the chain. So, for instance, where they haven't been paid a portion of the work that they've done on a particular project, they're able to claim up the chain against the money that might be due from the developer to the insolvent company. And it's not just limited to money that's due under the under the contract. It also relates to other financial instruments such as bank guarantees, letters of credit. So that's a really useful tool. There are, and it's something that all of the stakeholders need to be aware of, because there are liabilities that attach to a developer if they just ignore it. They can become personally liable for the money. So if they were to ignore it and pay the money through to the insolvent company, then the developer, once served with relevant notices under the Act, they'd be liable, even though they've already paid the money through. It's not a defence once they've got the notice. So there are things that they need to do, which we can discuss further when we look at their rights. So that's without a doubt the best that they've got. Of course, it's only useful if there is money due up the contractual chain, and it is specific to the particular project. So if there's money due on other projects they haven't done work on, they can't access it. So it's confined to the contractual chain that they're in. But it's a very useful tool. Unfortunately, other acts around other states in Australia and territories haven't, that I'm aware of yet, incorporated. It's actually quite an old provision, which has been reincarnated into the BIF Act. It used to sit in its own act, which strangely you would think that other states would have adopted it. So that's probably the best tool available to them, because they become secure creditors.
And always make sure you go speak to your lawyer when you're doing those, because there's a lot of formality to it, I can imagine.
There is, and in fact the cases are full of examples where judges have made comments about unfortunately oversights in the process where and it's brought somebody unstuck, which would have otherwise had a valid claim. So definitely, and I would say the theme throughout this is that in the construction industry, it's essentially contractual law. You do need to see specialist construction lawyers, be they a solicitor or a barrister, to get the advice, because it's heavily regulated. There are some real nuances to the contracts which are specific to building and construction. We can talk with those later, but one example, of course, is liquidator damages and defects. So the caveat throughout this is it's really important to seek specialist advice and at an early stage, because a lot of these remedies or tools are actually time sensitive.
No, that's good to know. And so they've obviously got their subbies charge rights. Are there anything else that comes to mind? Like, say they don't, the developer doesn't have, isn't owing any money to the builder for whatever reason. Is there any other rights that could help them?
I suppose they obviously have their entitlement to prove in the insolvency, but that's a less than adequate remedy in many circumstances. That'll be obviously contingent upon them, being able to prove either on when it's due under the relevant contract, or alternatively on a quantum error basis. So those typical, what lawyers call general law entitlements. They can, of course, avail of the security of payment legislation, and in Queensland that's embodied inside of the BIF Act. But all states and territories have analogous legislation. Usually they're standalone pieces of legislation. Unfortunately, under that, they're unsecured creditors. So it doesn't put them in a better position, unfortunately. They still end up as unsecured creditors.
So moral of the story for subbies, definitely go see your construction lawyer specialist or your construction law barrister to go and talk about the Subbies Charge Act, because that's probably, or the subby charges, I should say, that's probably your best bet, I guess, if it's available. Everyone does love to have that elevation of priority, so I can certainly imagine that. And unfortunately, especially here in Queensland, it's not like, so once it goes into external administration, the licensing regime up here is such that you pretty well cannot trade anymore. So a lot of the time you can't actually finish any of the projects or whatever. So invariably, it's very difficult to recover any of the debtors. So if you don't avail yourself of that subbies charge, then it might be that you get nothing out of the dividend and the liquidation, or maybe not. There are other avenues for a liquidator. So in terms of investigations of directors and related parties and that. So something might come to fruition there. But is there anything else you wanted to add for the subbies, or we can move on to developers?
We could probably move on.
Yeah.
I think, yeah.
All right. So developers. So the developer in the situation has. So we're actually probably talking about multiple different developers, I should say. As I said earlier, each of the projects are at different stages.
Yeah.
So each developer is in a bit of a different, unique scenario. What are its rights, or what are its key things that they should be thinking about or worried about?
Okay. Well, the developer, its concern will obviously be completing the project and doing so as quickly as possible. Usually developers are pretty sophisticated in my experience, and they typically already have a construction lawyer that that's trusted. So they're usually in pretty safe hands. Though where you've got perhaps a greenfield developer, so it might be a one-site development. They may not be so sophisticated and have that support around them. So one of the key things to bear in mind is that they need to obviously take proper advice before terminating the contract, rather than just simply acting on that. And just because a company goes into administration doesn't necessarily, obviously, and you can probably speak about this. I think you're going to anyway. It doesn't automatically terminate the contract. Position is somewhat different in Queensland because of the licensing issues that are attached, but the ipso facto provisions essentially help quarantine for the time being the operation of contracts which might otherwise result in a termination. Just by operation of the relevant provisions. So,
and that's generally because they've got into liquidation or they're deemed insolvent or whatever.
Yes.
And then they just automatically terminate the contract.
Yes.
And then hit you with every other claim afterwards.
Yeah. So I'd say for the developers, take advice about that and whether or not it's appropriate to terminate. Assuming that they've terminated, they'll obviously taking stock of the stage that the particular construction is at, and marking in the point of time, usually with experts, be they quantity surveyors and perhaps building consultants. You can go through too and identify the status of the work. So if there's any underlying defects, document all of that, because later on when they come to run those claims for defects and incomplete works, having a good set of records that they have in place themselves is really important. And then that will, of course, assist them with tendering with respect to any new contractor that comes in.
Yep.
Another really important point to bear in mind is that usually contractors will have some form of insurance.
Yep.
And so that insurance might be something that's required under a particular contract between the contractor or and the developer, or it might just be their own standalone insurance policy that they have generally. So it might be a project-specific one, or it might, and this obviously is in relation to very large companies, particularly infrastructure projects. But usually there are contractors, especially in the building industry, have got their own standalone insurance. And I noted the master builders in Queensland have got a pretty robust policy that names the principal, identifies the principal of the project as being an insured. So it actually gives them a separate right under the policy to recover against an insurer, rather than going through the company itself, which is obviously a lot more desirable. If
I did not know that.
Yeah,
so, that's very interesting.
Yeah. So if there is, and that just happens to be the nature of some of the policy in the master builders, one of their suite of contracts. But obviously other insurance policies, even if they don't name them as insured, they would still have a right to pursue under the contractor for any defective works, and depending upon the nature of the policy, there might be some other claims that might be available that could be claimed also on the insurance policy. Obviously, that would be first that'll first be against the construction company in liquidation.
Yeah.
An important thing for liquidators to understand too is that assessing those claims appropriately it actually can assist with the overall assets available to the creditors. Because if, for instance, you can take out all of these claims that might be paid to a particular developer, and they get paid through an insurance policy, then all of a sudden there's more funds available and to the broader body of unsecured creditors. So it is actually in the interest of the broader body of creditors if they can appropriately process a claim for defects under a particular insurance policy. And typically, I think on the Act, in fact, they have an entitlement to recover any fees associated with that, and that would come from the proceeds of the insurance policy.
Okay. Yeah.
Now, it's well established that is any claim made on that policy is for the benefit of that particular creditor,
Yep.
And not the broader body of creditors. But as I said, it provides the benefit because you have actually removed a significant liability.
Yep. I'll just quickly pause you there. We've had a comment come through from Elias. Thanks for the feedback. He asks, he makes a comment, and I will say I have been following Elias actually myself on his LinkedIn, and I would strongly recommend anyone to give him a follow. And he always puts out really good case updates and updates as it relates to insolvency. But he makes the comment that that when it comes to ipso facto, that you should distinguish between that, I guess, terminating because of insolvency or terminating because of some, I guess, fundamental breach under the contract and stuff like that. So certainly that is right, and it is no doubt the principal or the developer will be looking for every little angle that they could possibly run to stop that ipso facto being a bar. So no, thanks very much, Elias, for the comment. Feel free, anyone else, if you would like to comment, just keep them coming, and I'll talk about them live as long as they're appropriate. You can tell me how much you don't like this afterwards. So, anything else with developers, or do you want to move on to external administrators?
I'd probably just go back to what I had foreshadowed earlier, which is in the context of subcontractors' charge, it's the developer or the principal who is required to pay money down the contractual chain if there's money due on their particular project. They have a risk of exposure for personal liability in circumstances where they fail to either pay the money into court or to set it aside and quarantine it and not pay it through to the insolvent company once the sub-discharge has been they've received notice of sub-discharge.
Yeah. So
that's really important.
Yep. Okay, no, great. So now let's look at my favourite topic, which is external administrators. So let's say we've been appointed. Let's start with liquidator, and then maybe we can very briefly have another look at that ipso facto as it relates to administrators. Let's say we've been appointed liquidator of Bob's Builders, and we're looking at a big debtors ledger. The 15 lots are at different stages of work. There's been progress claims in that issued. Maybe a couple of them had payment schedules given back by the developer, but they're just saying, no, we don't want to pay anything. Can you maybe just step us through why that might be? What are some of the issues that are being faced by liquidators? And then we can maybe talk about some of the solutions and stuff.
Yeah, sure. Well, before we started, you made mention of two key ones, which are typically an offsetting claim for liquidated damages, and usually that relates to delay. That's the primary reason. And another one is defects liability, which the standard of works may be deficient, and it'll be a rare project where every piece of work that gets done can't be attacked for something being wrong with it. It's just nobody in any industry does everything perfect all the time. So there's always going to be something that needs to get fixed, and in fact, most construction contracts even at the small level for residential developments. Small residential developments have a defects liability period.
Yep.
So the project is practically complete, and there's different definitions which we don't need to delve in now. But essentially, it's for all intents and purposes, it can be handed over to the principal. Then there's typically a 6 to 12 month period where the principal can get the contractor back to fix up little bits and pieces, and depending upon the nature of the project, it can be quite an extensive piece of work that's required. And it's important to note that one of the features of construction contracts is also that often there are retention monies held for that purpose. So the principal won't be paying all of the money over under the contract. They will, even after practical completion, there's usually something in the order of 5 to 10% retained. And depending upon the nature of the contract, that might be 5% that then that gets given back 6 months in 6 months' time, and the remainder in 12 months' time. So when we're dealing with liquidators, it's going to be important when liquidators are recovering money. It's going to be important that they understand the contractual regime that's available and what their rights are. So if we've got liquidated damages and therefore delay, then they need to understand the nature of the delay. And one of the other features of construction contracts is that there are usually a provision inside of the construction contract which permits the contractor to claim extra time. And that can be for various reasons. It might be, and really depending on what's in the contract, that could be for a delay by the principal for access or anything like that. So they can claim extra time. So one of the things that ought to be investigated is when did the works actually start on site? Because that's usually a trigger for the construction period, and then that is usual trigger for when it needs to be practically complete. And have there been any claims for time, additional time? Because that's essentially the formula that gives rise to liability for liquidated damages. So there are investigations that need to be handled. So in practical terms, what do we need to do as a liquidator to understand that? Well, my biggest tip would be identify very quickly who the people are inside of the organisation that you have been appointed to that understand the contractual claims process. So in a bigger organisations, there's usually one person whose job it is to raise all of these claims and all of the paperwork. Or there might be somebody who supervises all of that process. And so identifying that person early, identifying the repository where all that information is held, and in a small organisation like what you're describing, that's probably inside of their own system. But in larger infrastructure projects, the repository is often project specific, and that's transmitted up and down this conduit, which is project specific, and it's not necessarily emails. So identifying the person who has that information so that you can challenge and test these propositions that are put forward about delay. That's really crucial, and identifying the documents. And I mean, for liquidators, that's part of the bread and butter really in investigations, is going through that process. But too often I see, particularly in larger infrastructure projects, just in claims generally, once the project is complete or close to being complete, the workforce is quite transient. So they just go to the next big project. And so capturing that person's knowledge is really critical before they go. And in the building industry, particularly residential, it's probably less transient. But you still want to be able to maintain contact with them so you can chase them all up. And generally people are pretty good at assisting.
Well, we find our general approach would be like if Bob's Builders has gone under, we'll look to try to keep on a couple of the employees, maybe as under a license or a contractor arrangement with us for a period of time, if possible, unless if it's more so just the director who has that knowledge. And we try to get out as much as we can, and then see what we can do in relation to the debtors. But liquidated damages set off defects liability periods. I think it's the bane of liquidators' existence when it comes to construction. So
I'd probably say, Matt, an important thing is understanding the contractual arrangement that's in place, because many of the standard form contracts, other than for liquidated damages, many of the standard form contracts actually don't permit an automatic set-off as against payment claims that are issued. Another important characteristic is understanding whether or not each of the stages are severable and create their own obligation, and without getting into too much technicality about it, that can be relevant as to the nature of claims that can be pursued by a liquidator. So we have what's referred to as a lump sum contract. The ultimate obligation to pay under the contract by the principal is for the performance of the entirety of the works. But we've got severable portions, then each is a separate obligation. So that understanding the contractual arrangements and the rights which are created, accrued rights that are created under the contract, really important. And again, going back to somebody with some specialisation inside of this in construction law is key to understanding that.
No, that's very interesting information. Do you want to talk a little bit about retentions, or we can certainly move on to, I guess, just very briefly on the QBCC right of, or I should say Queensland specific rights to continue the work once the liquidations have happened. I certainly, I think the default position is that you really can't.
Let's talk about why that is. There are, as we mentioned earlier, there are financial requirements that need to be met for particular levels of licensing, and once essentially there are defaults under that regime, then essentially the license gets revoked. And once the license is revoked, if it's work that requires a license to be done, then Section 42 of the QBCC Act makes unlawful the performance of that work. So it's the liquidator essentially then can't continue with that work. In its own
there
right.
can be some workarounds in the sense of if you're at 95% complete, you might be able to convince some other builder to come in and finish the project, and there could be a profit share arrangement or something like that. I have seen that before, you just got to be careful as to how you do that. But in Queensland, it's very difficult to get a lot of those projects completed. But that's why we were talking before around this ipso facto idea for other states, other territories where they may not have that type of level of restriction.
And the problem, of course, is that once the company's in liquidation, particularly, the principal is probably going to terminate the contract. So
they'll find some fundamental term or potentially.
So but the company in insolvency, the company that's in liquidation, I should say, is then not going to be able to perform under the contract.
Okay, well, if anyone else has any other comments or feedback or anything, please feel free to message through. We generally, so this SV Partners Live session on LinkedIn generally goes for about 40 minutes. We try to not take up everyone's full lunchtime break or anything like that. But there is a full recording that goes onto my page after this. So feel free, if you want to go back and rehash anything what we've talked about. If you have any questions arising out of that, please feel free to ask the expert or message me and I can pass it on to Declan. But if there was any take-home messages,
there's probably 2 points that I'd like to raise. There are some misconceptions about the use of security of payments legislation provisions that can assist the liquidators. So just because a company's gone into liquidation doesn't mean that it can't avail the security of payments analogous provisions throughout the states. It's well established, certainly in Queensland and New South Wales, as a court of appeal authority to support the fact that they can. So it's a very, very useful provision that can be used, or process that can be used. Rapid adjudication, particularly in circumstances where there may already have been accrued rights under statute. And in Queensland, they don't even need the invoices that constitute the payment claims don't even need to be endorsed with the Act. So the threshold is very low. It simply needs to describe appropriately the work, the subject of the claim, a request for payment, which can simply be the word invoice, and an amount that's payable. So threshold is very, very low.
That changed in 2018, I think, sometime around then. Before that, you definitely on all your invoices had to write, this invoice falls under the Security of Payments Act or whatever it was.
Yes, and in other states it's still a requirement. But what's often not known is the fact that historically liquidators were turned off the process because they were concerned that they wouldn't be able to recover. But even when they succeed in the adjudication. But Seymour White Constructions and Ostwald is a good example of where the New South Wales Court of Appeal dealt with the issue. And so what the key thing with it, though, is there are strict timelines that need to be adhered to. And so when that ledger comes in, going through, having a look, identifying have there been payment schedules that have been received, has the money been, if there's an admitted amount, has that been paid through, it hasn't, and then understanding the process, which is a little bit of a choose your own adventure under the Acts as to how you go about it. But assuming that, for instance, that they did miss a payment, they didn't respond with the payment schedule, there is that right to go to court and have it somewhat summarily determined and obtain a judgment, which can be acted upon. So it's pretty powerful, and the defences are pretty limited in that. So, set off isn't one of them. So it's a very useful tool that if it's appropriately vetted, that debtor's ledger, it can be used well in pulling money in quickly.
Anything else you'd like to add?
There's one other tool which is again available in Queensland, which is not residential specific, but it is it does relate to project bank accounts. So for projects projects over $1 million, the Act basically created essentially a trust for funds to be paid into, where monies would then be paid out for the purposes of contractual payments under the relevant contract. That was public sector. In March 2023, it'll be applied to private sector projects above $1 million.
I thought it was coming up relatively soon.
So the full rollout is in March 2023. So that's certainly an area, particularly once it rolls into the private sector, to watch out.
Will be a lot of work for everyone involved. All right, great. Anything else you like to add?
I'd probably just say, for liquidators, remember the tools that are available in the Corps Act. The notices under Section 530 capital B, and also public examinations of staff and people with knowledge of the examinerable affairs of the company. So they're really powerful tools that can be used, and they should be used more.
Great. Well, thank you very much, Declan, for coming in today. For those who are still online with us, which we've still got a few, I'd just like to say thank you very much for coming, attending and listening to this presentation. If you want to get in contact with Declan, he is tagged in quite a few of my posts and that, so go check out his LinkedIn. Otherwise, he's at the Alfred Lutwich Chambers here in Brisbane, level 27. Pretty sure,
Santos Place.
Santos Place, so you can go door knock and say hello. please, if you have any other comments or questions, if you want to go back and rewatch it and then ask, feel free to either message myself or Declan, and I'll be happy to help. But thank you very much for tuning in. We'll probably, I would say the next LinkedIn Live, we're still working out if we're able to do one in a couple of weeks' time. We're just waiting on our my co-presenter for that one to confirm, but otherwise it might be in the new year. But we have a massive 6 months of some pretty awesome people coming on board, so I can't wait. Thank you very much, Declan, for being one of my early guinea pigs. So thank you.
Thanks, mate. It's been my
All right.
pleasure.
Thanks, everyone.